Thanks, everybody, for being here. Really appreciate you coming to our panel. Hi, I'm Stu Levy. I'm a partner at Skadden Arps, law firm here in New York. I co-head our Web3 and digital asset practice. And for most relevance here, for the past couple of years, most of my work has been in the NFT space, representing a variety of sports leagues, brands, entertainment companies, some global brands that have, that's not their, NFTs are not their day job, and then some native NFT projects, helping them get off the ground, and wrestling with a lot of the issues you've been hearing about a lot this morning, including intellectual property issues. I'm going to let each of the panelists introduce themselves, and then we'll dive into some key issues.
Okay, I'll start. Thank you. This is Zeynep Ekinci. I am a lawyer based in Istanbul, working at a firm called Cabinet Law Firm. In my humble opinion, best place to work in Istanbul. And I recently graduated from my master's degree of Istanbul Bilgi University Institute of Law and Technology, where I write my dissertation on the implication of non-fungible tokens on art law.
Hello everybody, thank you for coming. I'm Sen, I'm a lawyer based in Prague, and in my legal practice I focus mainly on blockchain, and next to it I have a company providing blockchain services, and our main focus is on designing and building blockchain solution to enterprises, creating NFTs of artists' works and supporting crypto startups. So I'm more to business and also lawyer.
Hi everyone, my name is Kayvan Ghaffari. I'm general counsel of Maker's Place, a premier NFT marketplace. I've been general counsel for a year now, and prior to that I was in private practice for 8 years, and I represented a variety of blockchain, Web3, NFT companies. I really got my start with Maker's Place doing IP due diligence on Beeple's first 5,000 days. NFT, and so dove right in with one of the biggest NFT projects in history, and from my career, the rest is history.
Hey everyone, my name is Ariel Givner, the founder and principal partner of Givner Law. I do corporate and intellectual property with blockchain and Web3 companies. I guess most notably, I helped facilitate the acquisition of the Solana monkey business IP from MonkeyDAO. That's been a very big thing in the making. And I really help with NFT projects and kind of just, I call my firm the Swiss Army knife of NFTs. We help get all of the entities set up. We help to, if they want to be a legitimate DAO, we help them come up with an offshore company. I do all of their IP, their trademarks. Nobody has really done many things with copyrights, but I mean, we can talk about that. And yeah, so pretty much whatever an NFT company needs, or even a company that wants to venture into blockchain, I help them get started and really just try and pave the way for them.
Kayvan, why don't we start with you, because we've heard a lot of different perspectives the last couple of days this morning, but what we haven't heard is how IP issues shape or come across your desk at a marketplace, and what are some of the issues that you think about and wrestle with, and that might translate into the broader community?
Sure. There are actually a few issues that I think about when it comes to IP issues for Maker's Place or just an art marketplace. One is the obvious, it's this DMCA cease and desist. So if there's an alleged copyright infringement of an NFT on our platform, we'll get a cease and desist, and I have to make a determination on how to take it down, whether to take it down. But the issue that I think is going to be really interesting for this industry, as I anticipate we'll see more cease and desist, more litigation on infringement, especially in light of the Hermes decision and others, is, well, if it's minted on Maker's Place, I can remove it from our user interface, right, from our website. But that asset is still minted on chain, and it is still indexed with OpenSea, LooksRare, Rarible. Am I going to be responsible for reaching out to those marketplaces and saying, hey, given that this was a Maker's Place minted contract, you have to take it down? Or does that rely still on the artist or the brand or whomever is issuing the cease and desist to go to every marketplace to do it? And so I think there's going to be quite an interesting set of dynamics with that. Another thing is, with trademark. The Hermes decision, I think, really, in my mind, kind of changed the game with trademark infringement, because Hermes did not have trademarks on digital assets. And didn't even apply for them. They actually applied for trademark registrations, I believe, like a year and a half after the lawsuit was filed. And yet the court and the jury still found that their existing trademarks in the Birkin was sufficient to expand to the scope of digital assets. And so I think we'll start to see some conversations about the expansion of IP rights in this new digital realm. And then I think one of the interesting things is licensing. If you mint on Maker's Place, the license is a Maker's Place license. But if you buy that token on the secondary market in OpenSea, whose license are you actually adhering to? Is it OpenSea's license? Is it Maker's Place's license? And so I think we'll start to see some really interesting discussions about downstream licensing.
Yeah, I was going to add to that second. Just for folks who aren't familiar, the Hermes lawsuit was a lawsuit brought against an NFT artist, Rothschild, who created a series of NFTs called Meta Birkins, a riff on the Hermes Birkins bag. They looked like digital images of Birkins bag, but in finishes like fabrics, like fur that Hermes does not do. Hermes sued for trademark infringement, saying that's confusing with us. People think, and in fact, they had some favorable news articles for them where people said Hermes has released NFTs. They were able to come back and say, no, we haven't, that's not us. Rothschild's big argument was First Amendment expression. I'm just an artist. I'm riffing on high-end goods and Hermes and their bags, and I'm just making an artistic statement. The jury found recently in favor of Hermes, saying no, that was good old-fashioned trademark infringement. You're trading on their name. Let's pivot back, though, to the license issue, and I wanted to add some comments on that.
I did. So one of the topics that has been brought to my attention recently has to do with licensing and, with clients that have CryptoPunks or a Bored Ape. And let's say it's Twitter and it's their profile picture. Well, what if there's another account that has a lot of followers that is using their punk? Okay, let's say this account is anonymous. They contact me and they're like, this person's using my IP, they're using this, how do I get them to stop it? And regardless of my opinion, it's interesting when, an anonymous account with a lot of followers does seemingly break, an exclusive license somebody has. And it's how does that get enforced? Is it even enforceable if that person bought it off of secondary? Because, as you said, does that license transfer? And I think that these are all issues that may have been kind of in the background before, but I think as, litigation and especially after the Hermes trial, things are kind of being brought to light. And I'm personally curious as to how that's going to move forward and what's going to be done about that, because people think they're buying an exclusive license. Are they actually? Are they buying anything?
And I think what's also interesting about that, and we'll hear on this side of the room, is as ordinals become more popular, which are sort of their inscriptions, their version of NFTs, there's even less of a chance that any sort of license agreement that you've signed on to is going to travel, as Kayvan and Ariel were saying, with the NFT, creating all sorts of issues that when I'm a downstream purchaser and I get that NFT, and there are all sorts of terms and conditions that attach to that, does that license agreement travel to me? And equally importantly, if you're the issuer, does any restrictions I've imposed on that carry forward with the NFT? The example we often give in our group is, I sell an NFT as a ticket to an event, and that had certain restrictions. You have to be over 18, you have to live in a certain state, whatever it might be, you have to own our product. And then that NFT gets sold and resold and resold, and now someone shows up with the NFT. They never saw the terms and conditions because they didn't travel with the NFT. When they clicked on it, they didn't see anything. There was no click here to see our terms and conditions. And all of a sudden they find out they're underage, they don't have the right credentials to get in. Obviously very annoyed. They think they bought the NFT and that came with everything, but they never saw the underlying terms and conditions. Go ahead.
Yeah, I just want to add to what's said about Bored Apes. About Bored Apes.
We're good friends.
How a person, an owner, NFT holder of Bored Apes, can protect against somebody who just used the ape as a profile picture. Under the law of my country, which would be very similar to the rest of the EU, a non-exclusive holder of the license, which is practically every NFT holder, cannot request the infringing party to stop doing that on its own. They always have to do it through the author or through the copyright owner. So it is also very impractical. So.
You want to talk about from your perspective how that would play out?
Yeah, of course. I think there are like several issues that I'd like to touch upon licensing. So one of them is for the jurisdictions where whenever a license has to be made in a written contract, you have to, for the passing and transfer of license, I think it's very important where you're actually putting this license. So I think it's very important that the brands or the NFT minters should be very careful about where to create and put those licenses. Is it going to be on the metadata? Is it going to be on the smart contract? Is it going to be separately written? Or is it going to be a license clause, which is actually in a terms and condition, which is actually in a jurisdiction who even doesn't require a written license contract? So there are lots of these kind of questions, and I think it's very important to touch upon this issue. And I think second important thing about licenses is that everybody is currently talking about, you have to be very careful with the licenses that you give, which is like a primary, principle, right? But what about the licenses that you might have given 20 years ago? I think in the Tarantino versus Miramax case, we saw this because there was a dispute which was later settled between Tarantino and Miramax, and there was a license agreement which was given for the Pulp Fiction movie back in 1990s. So if you are not in a time where technology is not developed, and if you're giving away some licenses, you have to be very careful. Do those licenses actually extend to the NFTs right now or not? Miramax was saying that they were not extending, but Tarantino was like adamant that they were for his exclusive rights. And I am a Turkish qualified attorney, so we had the same kind of disputes in Turkey, which I like to discuss so much. In the 80s, there were like vinyls. Everybody was like doing vinyls with their musics, and everybody was like writing their contracts only to include vinyls. And what happens 10 years later? You have the CDs, and afterwards the USBs and the MP3s, and right now we have Spotify. So you have to be very careful about the past licenses as well. And I think it's important that the firms maybe should have like a more proactive approach as to carefully consider what the licenses are and how can they maybe terminate the existence licenses with other parties.
Great. So I think it'd be interesting to hear, maybe you guys can speak to this, is because often, we all have here in the U.S. a U.S.-centric view of issues that come up on what is otherwise a very global product. So here in the U.S., a license agreement is not binding on a user unless it's been clearly and conspicuously presented to them and they manifest assent. They click on I agree or something like that. So just, the conventional wisdom today is just sticking a link in a smart contract that unless you're an engineer, you wouldn't even know where to look and find it, is probably not in itself going to create something binding. How would that play out in the European market?
Yeah. So firstly, it's a big problem with exclusive licenses because the license agreement in which there is exclusive license provided, it must be in written and signed. So I don't really think that written license in blockchain or just ticking a box is a huge question whether it would be considered as all right. However, I think that with the non-exclusive license, the terms and conditions are perfectly fine because by ticking a box, you just accept the offer. And if it's inscribed in blockchain, it's a tough question. I don't know. We don't have any core decision that would deal with that.
I agree. For the exclusive licenses, it all comes to the point, what do you mean by a written contract? So are the smart contracts are written contract in a general sense of way? There are still like debates. There are like some people saying, yeah, this is enough, like there is some code and it has some kind of data in it. And there are some people who said, no, it's not a written contract and you cannot put everything in the smart contract to be understood by everyone else. So I think it's still debatable, but the answer to this debate is going to end up as to how do you define a written agreement.
Got it. Kayvan, back to you. So one thing I want to ask you about to talk to, and then we switch a little bit to AI for a couple minutes. So do you and your counterparts at other marketplaces sort of compare notes? Do you guys sort of try to coordinate how you're approaching things, deal with it, talk about issues you guys are each dealing with? Try to have sort of a unified approach, or is everyone sort of going in a different direction? And then we'll talk a little bit about AI issues.
Sure, I think that's a really good question. I think for the most part, the answer to that question is yes. It's still a really nascent industry, right? NFTs have been around for 5 years. Maker's Place was started in 2018. Same with Super Rare, OpenSea, and like the OpenSea founders and the Maker's Place founders are actually like really good friends from Pinterest back in the day. And so we actually have a lot of conversations with each other on licensing and also royalties, right? Like that's a really big issue. How do you get secondary royalties? And that's not really done efficiently on chain right now. And I know there's a lot of protocols and new ERC licenses that are being tested to enable that. But for us, we speak with OpenSea on a monthly cadence to like reconcile what we believe are secondary sales to enable our artists who mint on our platform to actually get those secondary sales. And so I do think that for the most part, at least from a legal issue, the organizations do collaborate in order to get it right.
Great. And I'll let you keep the mic. Talk a little bit about artificial intelligence and how you see that. I know we've talked about that sort of shaping the NFT market as we kind of move forward.
I think it's a fascinating area. I'll just start with that. I think AI is fascinating. I think it's incredibly powerful, but I think there's a lot of concerns from a lot of people on the industry side or like the community side. A lot of people are like, "Oh, is AI actually art?" Right? If you just put in keywords to Midjourney and it pops out, is it actually art? Artists, on the other hand, think that it's going to replace them as artists. Buyers may not want just a pure output from Midjourney as an NFT. They want something a little bit more, quote unquote, human created, layering, further refinement of the keywords or the phrases or the themes. And then you have this debate of AI versus generative AI, like art blocks, Fidenza, Tyler Hobbs, Chromies. And so I think there's a lot of interesting conversations that are happening right now at a really hyper fast speed, given the speed in which the technology is developing. Right, Midjourney 5 just came out a month ago and is incredibly powerful. It's a beautiful technology, but with great power comes great responsibility, right? And so a lot of like marketplaces are starting to have conversations about what do we do in those instances. Do we want to identify pure AI art on our platform for our consumers? And whether it's copyrighted, right? That's a huge issue. That's going to be, I think, it's presently litigated at the district court level, and we're going to see, juries or judges start having determinations as to whether outputs from Midjourney are in fact copyrightable, because that'll affect the way in which brands and artists will want to go about licensing their work or enforcing their work. And then I actually think the Warhol opinion that's currently pending in the Supreme Court is going to have a huge effect on art in general and AI art as to how much. So for those who don't know, Prince's estate is suing Warhol's estate for Warhol's, I'm going to say Warholification of a Prince picture, claiming that it's copyright infringement. And the district court, I think, held that it was fair use. The Second Circuit held that it was not fair use and infringement, and now it's pending before the Supreme Court. And I think that's going to have a pretty interesting effect on art in general. And I think AI art, because Warhol did do human intervention to change an output, right, to change a picture. And I think how the Supreme Court rules on that, I think, could affect the Midjourney Stable Diffusion cases.
I want to touch on that real quick. Also, I like Warholification. We need to coin that. And this is just for the audience members. Something that I've noticed and have been approached with is, when you're an artist, let's say you create an art piece, you own that copyright. You solely own it, unless you create it with somebody else and there's joint owners. But for all intents and purposes, you create art, you're the owner. If you use Midjourney, and this is something that I have encountered some difficulty with, Midjourney retains an irrevocable license, and a lot of artists are they're miffed by it and they're really surprised by it. But that goes into, are those terms clear? Are they upfront? And are people being made aware of that? I've had one deal went through with an artist and a brand because the brand wanted something where they could buy the copyright. The right was completely theirs, but the art was created on Midjourney. So Midjourney retained some license to it, and the brand was very unhappy with that. And I think that it all comes into, is it the artist that's putting in the keywords? Yes, Midjourney is the software that they used, but should they maintain that right? And that, I think, is a conversation that would be very interesting, and I'd like to know your opinion on that.
I think what's going to be interesting about that is, well, what's the output from Midjourney, and then what's the ultimate end product? Because if an artist is continuing to iterate on that end product, well, what is Midjourney actually getting? They're getting that initial draft, right? And so is the later created in time art subject to that license by Midjourney? I would personally argue no, because I think there is a level of human intervention and distance from Midjourney because they are editing it with other tools or whatnot. But I think it is going to be an interesting question. What's the scope and breadth of that Midjourney like non-exclusive license?
For what it's worth, that's what I said to the brand, but they were not having it.
Yeah, and one thing which is interesting, just bringing it over to the NFT space, because some have started to question, and Ryder Rips, who's an artist who's in a dispute with Yuga Labs over this, has raised this issue, is whether the creation of generative NFT art is not protectable. And the argument is, well, didn't a computer create that? In our view, and I think there's different views you can have about this issue, in our view, it probably is protectable because what the Copyright Office has looked to is whether there is a level of human creativity and intervention. So it's not like for NFT projects, it's not like an AI project historically where someone typed in a bunch of keywords, got some art, and now sold that as an NFT. Usually you had a human artist create different character traits, different elements, then created a computer program that molded those together, but with a set of human-created rules. So the hat's not off to the left, the hat is sitting on, whatever the image might be, the glasses are in the right place. Usually a human does some quality control and says, okay, this, for whatever reason, there's a glitch, it didn't work out, and throws those out. And there's very likely enough human creativity in NFT projects where you've got, the one of 10,000, where even though you had a computer stitched together the final piece, that you could still claim that there's enough human creative elements in that to protect it, although I think we're going to see a lot of arguments of people arguing that it's not protectable and they can go use that. We've only got a minute or two left, but maybe we'll do something which I don't think we've done enough of this morning and see if folks have questions in the audience that things come to mind. Yes?
I just was wondering if you could comment on the Getty Images lawsuit.
The AI one? Sure. Do you want to comment on it? I can.
European?
The Getty lawsuit? Yeah.
I'm not throwing you off, quite the opposite. This is such a great session and it's standing room only. We've just found that we can give you an extra 5 minutes. Oh, wow. Yeah, so thank you.
Yes, I'll comment for a minute on the Getty lawsuit. So there's two issues in the world of AI today. One is the output that comes out of a program and whether that's infringing or not. That's some of what we've been talking about. But the way AI models are trained is by feeding in images, and that's how the AI models learn what art is. As crazy as that is a concept to get our heads around. And so if you pumped in art that you just created on your own, let's say, no issue. But the issue becomes, what if I start using other people's copyrighted images to train the model to create art? And assume, or photographs, or whatever it might be. Assume for a minute the end product doesn't look anything like the beginning product, right? Everything looks totally different. No one can claim, wait, that photograph looks a lot like my photograph. Question is, can you have an argument that just using my photograph to train your AI model infringed my rights? And that is what, in the Getty lawsuit and a couple of other lawsuits involving artists, people are arguing. Getty has said, Getty's big photo catalog warehouse, Getty has said, you sucked in all our images. Important note that all of us as IP lawyers always mention the fact that something's on the internet doesn't mean it's in the public domain, just means it's on the internet. And the fact that you can access an image doesn't mean you can now use it however you want. And sucked in all these Getty images as part of generating the end product. Good for Getty, really bad for the defendants in that case. Getty has some terribly, terribly powerful examples where you can actually see, so Getty watermarks its images. You can see the Getty watermarked image, but kind of distorted because it's run through an AI machine. So, the AI machine doesn't realize that's a watermark, not part of the image. So you can sort of tell it's Getty, but kind of, diffused. And so it'll be interesting to see, to Kayvan's point about the Warhol case, how much transformation you need to do for something not to be infringement anymore. But it's Getty has presented a very powerful case because the examples they're giving really show their images being used in this model and potentially the output even looking like their images. Yeah, please.
I think it's an interesting case because I think they have a much stronger case than the Stable Diffusion or Midjourney plaintiffs, because I think in those cases what's interesting is abstracting, like what is the AI engine doing when it's training on all this data, right? Is it actually copying that data, ingesting that copied verbatim data and training it? Or is it abstracting themes, elements, color palettes, right, from the underlying asset in order to train? And that seems, that if under copyright principles, I think that actually isn't infringement. The storing of the images for purposes of trading would be, but I can imagine in my personal opinion that might be incidental infringement that can withstand fair use. And I just think from like a public policy perspective, or just like a human perspective, people become artists by like learning and reading about other artists, right? They'll go to the libraries and they'll take a book about Picasso and like spend years reading Picassos and looking at their images, doing sketches in the form of Picasso, and then we'll create something that has like a Picasso-esque appeal to it, right? That doesn't mean that they're directly infringing things. And so I think that level of, that analysis of what is the actual AI doing, is it just abstracting the elements to train, or is it verbatim copying, is going to be important. And I think that's why I agree the Getty is challenging, because they have the Getty watermarks.
Okay, other questions?
Concerns, comments?
Suggestions?
I have a question. I feel like we're talking about AI, and the whole week has been like, AI is a tool, and not so much something that's creating something. Was there ever any lawsuits at the turn of the century around photographs? Is like it's copying an image, and was that ever used in trademark law? And can you use that?
Constantly.
What?
I was just commenting. Yeah, that's been a topic for a very long time, and that's nothing novel. That's just point blank. It's been an issue. It's nothing new.
One of my favorite photography cases is about like ownership of copyright and whether it's human created or in this case a monkey created. And so it's a National Geographic photographer.
It's Naruto, right? The monkey's name.
Yeah. And this this monkey took a selfie right on this guy's camera, and the court ruled that that's not copyright eligible because it wasn't created by a human.
Could I please intervene and talk a little bit of UK right now, which is an interesting point of view. So I think under United Kingdom jurisdiction, actually the things which are not completely done by human beings are also subject to copyright. So it's like in the Section 9 of the Copyright and Patent Act, and this act is dated 1988, which is followed by a very, very important event, which was weighed on 1984, which is the showing of the Terminator movie in the film theaters. So apparently the UK legislators were really, really inspired by artificial intelligence. And they just told, okay, we're going to be able to give everything, everybody, not only human beings, but everyone else, any kind of technical, systems, copyrightability as well, which is very interesting. And UK was actually expecting that many, many jurisdictions would follow them, which didn't quite, turn out to be right. But in that respect, there is a very important criteria to think about, I think, because under copyright law, we're always talking about human element and originality. So even if those generative AIs can go outside of the criterion of being a human, are they still going to be original enough to be, meriting copyright? So even in a jurisdiction like the UK, generative AI cannot be, protected by copyright because you cannot maybe be passing through the originality criterion.
Yeah, that's a great point. I think with that, we'll bring that as sort of the wrap-up point, but I think it's such a great point to end on, because going back to something we've all been talking about is how global a view you need to have of what you're doing. And it's really complicated in this space. If you go back to the origins of the .com era, one of the issues people really wrestled with was, if I just have something in the US, but it's accessed globally because everyone coming to my website. Am I now offering that globally? Do I have to need to deal with global issues? Same thing even in spades in the Web3 and NFT space, where you just can't have, no matter what country you're in. We have a US-centric view here in the US. You can have a European-centric view in Europe. You have to really have a very global approach to these issues and appreciate they might get resolved differently depending on where you are, where the different parties are, where the work was created, and things like that. All right. Thanks to the panelists. This was great, great conversation.
Hello. Yes. This was such a great panel. Where's Mark? Mark and Andy and I did a panel yesterday that also was standing room only about the Top Shot case. And we promised that we would do a webinar later this month. I would love to invite you guys back to continue to talk about AI and NFTs on a webinar perhaps next month. You've been absolutely amazing. I had no idea that Arnold Schwarzenegger inspired UK lawmakers, and that's my take. That's my. I think someone has to tweet that, by the way. Yeah. It's okay. We'll take it. We'll take it. So thank you very much. It's been amazing. Yeah. Well done, guys. And Eric, come on up. Eric's going to talk about NFTs and tax now.